The section 189 is clear, it's explicit, it is without any strand of ambiguity that in the event that a governor transmits a letter upon return from maybe medical sojourn or so, it should just translate to him resuming office. But it is very surprising that people, either for want or desire or knack for whatever to position themselves, think they can circumvent the provisions of the sacred constitution that we have. It is as baffling as it is sad. For instance, some of them claim he did not author the letter. When do governors even write letters anyway? Or the president? What happens is he instructs, they instruct. And in some cases where such instructions are either carried wrongly, they usually will come up and refute either the content in part or in its entirety. But I don't see where in the Constitution it's stipulated that the letter must be signed by the governor, the president, at any instance. So I think it's more of mischief, really, than any other reason that is informing all this questioning about the authorship of the letter.
Some would say looks like, advice from his doctors. Maybe they've asked him to, take the back seat for a moment before coming on the saddle.
None of his doctors advise him to take the back seat. Politicians advise him to take the back seat for now. I don't know for what reason, some of which could be sinister.
You said you met with him.
Yeah.
What kind of thoughts did he have about governance?
He called me by my first name, Amimu Zang, and it's quite a number of years I met him last. And how else can you verify one's state of mind?
I mean, the fact that he didn't have amnesia doesn't mean that, he can stand the rigors of office. Let's...
Yeah, even the ones that are called fully well today, from time to time, go off for medical checks, go off for rests and the like, and nobody is saying no, he did not have an accident. He did. And nobody is saying he was not injured in that accident. Nobody is saying that. But that, as it were, he is recuperating for those things that he cannot do. Procedurally, he will assign such assignments to his deputy.
Does he know what is going on out there in terms of the kind of debates people are having about his availability?
About his availability to serve?
To govern, yeah. To continue governing.
He is there to continue governance. He is
So
contesting, in fact, the interpretation or the non-receipt of the letter he transmitted to the House by himself. These are actions clearly directed by him. He wants to assume office fully.
Is there any friction, perhaps, to your knowledge, between him and his deputy?
That much I may not know, but then the fact is, what you do must be in harmony with what you say. If, for instance, on the one part, and it miffs me when the governor and his cabal, though they are quicker to call some others cabals, say they are loved governor. In one vein, then in another, they say, no, this man is not well enough to govern, on account of which he should stay back and the like. This world, I don't know, human beings, we can be very funny. If you look at the circumstance of the arrival of this present acting governor, he came by providence, because, as it were, the former deputy had issues to sort out with the House, bordering on corruption. That's when he was removed. Then this acting governor was brought in. And even you will be surprised at this kind of backstabbing. So the governor, naturally, at this point, that's why when Ajura, though you said we'll get back to that later, was saying...
No, you can go ahead.
Yeah, he's talking slowly, and maybe he didn't know Governor Tsuntai. He is a natural slow speaker. that might have been compounded now by the injury and the like. And when you have an air crash, even if it is a road accident, you survive it. Tendency is that you'll be cautious in whatever you do. But then does that sum up to now saying you are incapacitated? In this case, incapacitation has to be evaluated by competent bodies.
We'll take our attention back to the developments in Taraba State. You do remember that the governor has been absent for a while now, and so we'll bring it back to the front burner. Nelson Quakers joins us this morning, Senior Advocate of Nigeria. Monana, thank you for coming on today.
My pleasure.
You know, when people talk about this, because I know that there was a time they talked about some other governors who were absent, and they had to take it back to the perspective of law, saying, okay, what is the provision? What are they required to do? How should they go about all of this? But now, it looks as though it's gone down for a while, but the law still stands. What are the requirements?
Well, it's very simple. It's a constitutional issue and not political. But regrettably, what we have in Nigeria is that political considerations are used to subdue and override constitutional provisions. Section 189 and 190, if read conjunctively, gives the impression or the picture that the State Executive Council has a burden and a responsibility to inform the House of Assembly of the State through the Speaker that the governor, having worked with him, they have realized that he is incapacitated to carry out or discharge his functions. Now, the burden is actually placed on the Council of State to do that. Now, the Council of State are a group of persons appointed by the governor to work with him, and oftentimes these are commissioners, and they're the ones in a position to observe whether the governor can discharge the functions of his office. Now, having seen that he can no longer perform, it is passed on to the Speaker. The Speaker sets up what is called a medical panel, in line with what the last Speaker also said about the need to also strengthen the medical field or healthcare. Now, a medical panel is set up of eminent persons, including the medical doctor of the governor himself, to examine and come up with a report whether the governor can no longer discharge his function. That's on one side. Now, 190 places a burden on the governor to transmit a letter to simply say either he's going on vacation or he can no longer perform the functions of his office. So you have these two levels. Now, you can see that essentially it's something that the Constitution has already envisaged. Now, you now have a situation like this. What is expected of the people in Taraba State, the Council of State in Taraba State, is simply to comply with the provision of the Constitution. But what is happening is the political consideration. The governor appointed me. If I blow the whistle, I will lose favor. That's what is going on. So it has now been politicized. So the legal requirement is not been implemented.
But if you look at the way it is now, and then they tell you, because if you read comments coming from, is it the acting governor now or the deputy governor? What do they call him?
The deputy governor.
He also says that he's not in a position to determine when the governor is going to return. And so, is that statement, how does that statement fit into the legal provisions?
It's a political statement. Clearly, it's a political statement. And I want to believe that the deputy governor is also playing safe. Now, Nigeria is a very unique country. Unique in the sense that we rather obey laws in breach than in practice. Now, there's a provision there. And then you have the council. The council's responsibility, and you remember that this is not the first time. You see, we have failed as a country to learn from the mistakes of the past. Under President Yar'Adua, it was the same thing. Yar'Adua was ill. Nigeria, the public were aware that he was ill. Certain elements within the government concealed that or tried to shield it from the Nigerian public in order to ensure that the incumbent president did not emerge as acting president. When there is a constitutional provision, all that is required is first transmit a letter. Now look, I can no longer discharge. First, I'm going on vacation, so I will not be in my office. I can no longer discharge the functions of my office. The constitutional provision is always there. But the failure we have, or the difficulty we have, is simply to obey it. Now, the deputy governor is also playing safe. If it comes out, he can't kickstart the process. It is not for him to start process. If he wants to do it, for instance, he can also do it clandestinely, and that is also not too good. It is actually the Council of State's responsibility to do that, because they are in a position to fly the kite that the governor can no longer discharge the functions of his office. It's as simple as that.
Now, don't rule out more reactions about that matter, because the last we heard of it was they were trying to settle out of court, but the courts have a way of featuring in this matter. Who knows how that will eventually pan out. Now, we grapple with infrastructural development on a regular basis, issues that bother on development of all sorts. This next one you're about to see was seemingly unique. A journalist had raised some issues about Abia State government papering over cracks rather than provide amenities, some of them basic amenities at that, for the people. But the then Commissioner for Information disagreed. Now, that generated so much reactions that set our Twitter handle on fire. You need to see this.